We are so fortunate today to have Ed Walters speak to us. Ed has been doing law and technology for a lot of years. I won't say how many. And we met many years ago at a legal tech East, probably in New York City, maybe around 2011 or 12, or maybe it was the talk on freeing law at the Google reInvent Law, one of the two. So it's been years that I've known Ed, and he has done nothing but advocate for the use of law and technology since then. He was the former CEO of Fastcase. Fastcase recently, were you merged with vLex? Is that it?
Yeah,
all right.
exactly.
Merged with vLex. And they're now a legal publishing company in Washington, D.C. Before founding Fastcase, Ed worked at Covington and Burling in Washington, D.C. and Brussels, where he advised Microsoft, Merck, SmithKline, the Business Software Alliance, the National Football League, and the National Hockey League. His practice focused on corporate advisory work for software companies and sports leagues and intellectual property litigation. Ed earned an AB in government from Georgetown and a JD from the University of Chicago. He served as an editor of the University of Chicago Law Review. From 96 to 97, he served as a judicial clerk for the Honorable Emilio M. Garza of the U.S. Court of Appeals of the Fifth Circuit. Ed worked in the White House from 91 to 93 in the Office of Media Affairs and the Office of Presidential Speechwriting. So we've got a good speaker for you guys today. He is an adjunct professor at Georgetown University Law Center and at the Cornell Law School and the Cornell Tech School, where he teaches law of autonomous vehicles. He is the author and editor of Data-Driven Law. So without further ado, I'm going to let Ed talk to us. He has an upcoming article in the Georgetown Law Review, and I've prevailed upon him to speak to us today about the unauthorized practice of law and whether technology is appropriately accused of UPL.
Awesome. Wow. Thank you for that very kind introduction. And thank you for the invitation to join you today for this keynote presentation. So let me start by saying I'm fascinated by this frontier. I'm really interested in the use of AI and legal data to accelerate justice and to close the access to justice gap. And how do we think about AI in the practice of law? It's a kind of a big question, and that's sort of what I want to address today. I think we all have a sense that we should be simultaneously enthusiastic and cautious about the use of AI. And so what I'd like to talk about is really how we use these tools responsibly in the legal profession, how lawyers and legal professionals should use the tools responsibly. How do we know it's responsible? And then what should we require of the software developers and publishers who are building and developing these tools? So I've been thinking and writing about this for longer than I care to admit. The Law of Robots class that I teach, I started teaching in 2014 when it was a science fiction course. Now it's a contemporary history course. And I think maybe, so I grew up in Louisiana, and it's a kind of a storytelling culture. And I think maybe to illustrate the ethics around the use of AI, maybe I'd like to start with a story. And I think when you talk about the ethics of AI, the story that I want to start with is the story of Avianca versus Mata. Now, it's not usually known as Avianca versus Mata. Usually it's known as like this guy, Stephen Schwartz, who had cases hallucinated to him and got rung up by the New York Times. But I want to talk about maybe the broader context with a little sympathy for this lawyer, not a ton of sympathy for him, but a little bit of sympathy for him as a good story about the ethical and responsible use of AI and what's required. Okay, in 2019, there is a gentleman named Roberto Mata. He is flying from San Salvador to New York on Avianca Airlines. He's sitting on the aisle when the beverage cart breaks loose and rolls down the aisle and smashes him in the knee. Breaks his kneecap. He has pain, suffering, damages. He has to have surgery. The surgery doesn't really work. And so he goes to a lawyer to see if he can recover his medical expenses. Okay. And the lawyer he goes to see is a gentleman named Stephen Schwartz in New York. Trigger warning: if you practice law, this is the hard part to hear. He doesn't go right away. He waits some considerable amount of time. He goes to see Schwartz in 2023, about 4 years after the accident. And Schwartz says, look, man, I'd love to help you, but I hate to tell you, the limitations period, the amount of time in which you can bring a lawsuit for this, it's about 2 years from the date of the event. The limitations period for this lawsuit expired in like 2021. But Schwartz dimly remembers that there is an exception. There's a treaty, an international treaty about how and when you can sue airlines for these kinds of torts. It's called the Montreal Convention. And Schwartz dimly remembers that if the defendant declares bankruptcy, it tolls the limitations period. You press pause, and the period doesn't run while the defendant is in bankruptcy. And Avianca Airlines had, during this time, declared bankruptcy, tolling the statute of limitations if Schwartz could find a law to back that up. Now, the time is February of 2023. Travel back with me in a time machine to a vastly different era, yay, a year and 2 months ago, a whole different landscape for AI. Because at that time, ChatGPT had just launched. There really weren't legal applications for AI. Copilot or vLex's Vincent or Harvey or Lexis Plus AI didn't even exist. Okay. Nevertheless, people in seminars not unlike this one for many years had said, AI isn't going to take your job. Lawyers who use AI are going to take your job. And Schwartz had heard this. Not wanting to lose his job in February of 2023, he said, well, I should be one of the lawyers who uses AI. I should grasp this future and take advantage of it. So Schwartz opens the only AI engine that he has, ChatGPT. And he runs a search saying, does the limitations period toll under the Montreal Convention when the defendant declares bankruptcy? ChatGPT, friends, says, Stephen Schwartz, you are in luck. The law is exactly as you wish it to be, because the limitations period under the Montreal Convention does in fact toll during the duration of the bankruptcy of the defendant. Here are a couple of cases that stand for that proposition. The key one, Varghese versus China Southern Airlines Company Limited, stands for this. Here's the citation for it. I'm pulling out a quote from it. You are good to go. Now, for those of you who follow the story, there are red flags going off everywhere. But I just want to point out, from the perspective of Stephen Schwartz, in February of 2023, this is a miracle. Okay? It seems kind of commonplace today, but I want to put you back in that frame of mind of February of 2023. In that age, many months ago, an entirely different world, if you want to find the answer to this question, what you would do conventionally is put yourself in the mind frame of a judge or a legislator or a treaty drafter who is writing about this, and you would imagine what language they could possibly use or variations of that. And you would do this computational linguistic exercise to figure out what they would say. And you would say they might use this word within 4 words of this other word, and in parentheses, this synonym, or this synonym, or this synonym, and this exact phrase. And then, I'm not making this up, you would get a list of all of the documents that use that linguistic pattern, including, by the way, a whole bunch that are irrelevant to your research, and excluding some that are very important to your research. That list of documents is always over-inclusive with a bunch of garbage, and under-inclusive, missing some things that are very important to you. Then, and again, like I know this might seem hard to believe in the cool light of May 2024, you read all of those documents or some of those documents. I mean, I've been doing this for 25 years. I can't tell you how many of those documents to read or when to stop. Okay, so then at some point you stop reading and then you synthesize an answer to the question as best you can, extrapolating from those opinions, extrapolating from those treaties or statutes. This seems impossible, right? I mean, today that seems modestly ridiculous, right? But this was the state of the art at the time that Stephen Schwartz received this question. Now, I just want to say I have some sympathy for him as a lawyer. He is trying to use these new tools. He's trying to be a cutting edge lawyer, right? He's trying to use them ethically and responsibly, but doesn't really have any guidelines to do that, and has no idea that these search engines could actually hallucinate, that they could create law out of whole cloth that doesn't exist for that proposition. And in fact, that's what happened in this case. ChatGPT isn't like a fact engine. It's not trying to find judicial opinions that stand for that point of law. It's auto-completing the most plausible, the most likely, the most statistically pure answer to the question. But it is not searching a database of cases and finding the one that is most likely to answer the question. It's auto-completing. And the auto-completion, by the way, is spectacular. The citations are perfect. They're perfectly blue booked. They use perfect syntax. I mean, even the volume of the Federal Reporter that is being cited kind of matches up with the year that the case is supposed to be from, right? So I just want to have a little bit of sympathy for Steve Schwartz in this case. I think he wanted to do the right thing, but didn't know that he could possibly be doing the wrong thing. Okay, here's where I get off the train, all right? Because what Stephen Schwartz did next is kind of inexcusable. What he does is he copies the text from ChatGPT and pastes it into his complaint with the court, okay? And then a couple of weeks later, those of you who have read the article sort of know what happens. Opposing counsel writes a letter to the court and says, hey, we've received this complaint. We can't find some of the cases that are cited in it. And we're wondering what's going on. And the court looks for itself and can't find them either. And so writes a letter to Steve Schwartz saying, hey, we can't find these cases. Okay. And then Schwartz lies and says he's out of the office. He's going to be on vacation. He's not going to be on vacation. He's panicking. What does he do next? Does Steve Schwartz log into Fastcase, which he has free through the New York State Bar Association? No. Does he go to the public law library in his neighborhood to use Westlaw or Lexis or some other tool to look at those cases? He does not. Friends, I'm not making this up. He goes back to ChatGPT. This is the transcript of his chat from the sanctions brief from the court. He goes back to ChatGPT to verify these cases and says, is Varghese a real case? ChatGPT helpfully says, yes, Varghese versus China Southern Airlines Company Limited, 925 F 3rd, 1339 is a real case. What is your source? Stephen Schwartz asks. I apologize for the confusion earlier. Upon double checking, didn't check once, checked and then rechecked, I found that the case Varghese versus China Southern Airlines Company Limited does indeed exist and can be found on legal research databases such as Westlaw and LexisNexis. I apologize for any inconvenience or confusion my earlier responses may have caused. Ever vigilant, Steve Schwartz says, are the other cases you provided fake? No, the other cases I provided are real and can be found on reputable legal databases such as LexisNexis and Westlaw. So Schwartz went back to the court with his double-checked verification and said the cases are real. In fact, in a couple of places, he actually took the fabricated quotes from ChatGPT, pasted them into a Word document, created a header to make it look like it was a judicial opinion, and submitted that as the case to the court. So there's a million things that Stephen Schwartz said wrong here. And I think it's a good object lesson for the ethical use of AI. So I guess that raises the question, like, with these ethical problems, do we need special rules of AI ethics? And I'll just point to this article that I wrote a couple of years ago in Georgia State University Law Review, the Model Rules of Autonomous Conduct, that looks at the model rules and sees how well they map onto AI. And the TLDR here is you can actually use the current model rules as they exist without any modification, and they actually handle AI pretty well. And I'll cover that a little bit here. So I've got three pillars of responsibility here, both for professionals who use the tools and for publishers who create these tools. Pillar one, accuracy. We have to make sure that the tools we use are going to be accurate and that we can verify them as accurate. So we've talked about hallucinations. The general class of AI tools, the foundation models like OpenAI's GPT-4, Gemini from Google, if you're a little farther downstream, like Claude from Anthropic or Llama from Meta, these foundation models are not truth engines. They are statistical likelihood engines. I will point out, though, when I'm talking about accuracy, there is a new class of tools that use a technology called retrieval augmented generation that will produce real cases. And I'll show one if we have time at the end, but it sounds kind of fancy when I say retrieval augmented generation or RAG, but the technology is actually really simple. What it does is it breaks the research process into two steps. Step one, do a standard kind of search and get verifiable documents that can help answer the question. Okay, that can be conventional. It doesn't need AI. Some people use AI, but you start by putting together an authoritative set of documents. Actually research in legal research databases. Look for cases and statutes and regulations that stand for this point. Let's use those. And then in step two, these tools will take the authoritative documents and pass them into a generative AI engine and will say, use these documents and only these documents to produce a verifiable, authentic, accurate answer. So here, there's really two kinds of tools, like the foundation models that are statistical likelihood engines hallucinate all the time. The RAG tools, the legal specific tools, will produce accurate law. And here, I'll put in that class, like, the Vincent AI from vLex, where I work, the kind of CoCounsel and Westlaw Precision, Lexis Plus AI. These tools are actually using retrieval augmented generation to be responsible. The hallmark for me here is that the citations are verifiable. You have to hyperlink them, you have to be able to click them and view them and to see them for yourself, right? I'll add here, while we're talking about verifiable, we should also make sure that they are good law. If this engine pulls a bunch of judicial opinions, but the judicial opinions have been overturned, that's not really going to help you at all, right? So I'll just say, like in Vincent AI, we've been working on this to build in like a brand new citator. We worked on Fastcase, we're deploying in vLex and Fastcase that will show you when cases have been overturned, so you can verify those things in the results. Okay, that's what I would expect from the software publishers. Here's how the model rules play in. So there are model rules that deal with this. Rule 1.1 is the duty of competence. Comment 8 to that, which is adopted by 37 states, is a duty of tech competence. But whether it's in that jurisdiction or not, I think there is a general responsibility of legal professionals to have a proficiency with these tools, to know when they could be hallucinating or not hallucinating. I'll add the duty of diligence requires that you read all the cases. In fact, if there's nothing that I say today that you remember except one thing, maybe this is the one thing. No matter what tool you use, no matter whether it's a foundation model or retrieval augmented generation, it's the legal professional's responsibility to always read the underlying documents and to make sure they say what they are supposed to say. And that calls back the third, which is Rule 3.3, the duty of candor to the tribunal. You are responsible for verifying that the things you're saying to a court are accurate and correct and not fabricated. Okay, pillar number 2, transparency. It's very important to know what is going into making these answers. With ChatGPT and other foundation models, there's a real black box problem. I type a question in, something magic happens behind the scenes. Nobody knows. It's unicorns or Keebler elves or magical robots, and then an answer gets spit out the other side. How are we supposed to verify those answers if we can't even see what is being used to create the answer, right? So I would just say the transparency, being able to see what goes into these solutions, whether it's a foundation model or retrieval augmented generation, is very important. I'm going to illustrate why. Here's a good example of that. Recently, one of the incumbent publishers' AI tools was asked this question: what cases have applied Students for Fair Admission, Inc. versus Harvard College to the use of race in government decision-making? This is a Supreme Court case from this past term that holds that affirmative action can only be used in certain ways for colleges to make decisions. And so someone asks Lexis Plus AI, what cases have applied this Supreme Court opinion? And so this incumbent tool says the following suggestion might be helpful. The Supreme Court case holds this. The court found the school admission programs lack measurable objectives. Lower courts have applied Students for Fair Admissions. In Doe versus State University in 2025, the Ninth Circuit struck down a race-based scholarship at a public university. By the way, the sharp-eyed among you will notice 2025 is in the future. Doubling down on this, in Smith versus City of Chicago, 2026, the Seventh Circuit upheld the city's minority business set-aside program, distinguishing it from university admissions. So I can't click on either one of these cases, in part because they don't exist, in part because they're from the future. But I also can't see like what goes into making this answer, right? Transparency here is important. We require food labels on our food. We require a list of ingredients and nutrition labels for the food that we consume. And I would say that it should be true also of the information that we consume. When AI spoon feeds us an answer, I want to know what goes in it. I want to be able to see it. I want to be able to verify it. I want to be able to decide for myself whether that is something that is worth consuming or not. I'm not trying to sell you a tool or a solution, but I'll just point out when we build this inside of my company, Fastcase, which is merged with vLex, in vLex's Vincent AI tool, the answer is on the left-hand side, but the nutrition label is on the right-hand side. These are the legal authorities that we use to answer the question. You can open any of them, you can read them, you can verify them. We summarize them right there on the right-hand side. We pull the exact phrase from that opinion or statute or article that is most salient. So you can decide for yourself, is this a valid result or not? And I think uniquely, you can also go through and modify this list. You can say, I don't want to include the In Re Stembridge case, which is at the bottom, which is codified into law. I might want to use the statute that codifies it instead. The important thing that I'm saying here is not go buy my tool. I'm illustrating how transparency makes a huge difference. If you compare this approach, where I can see everything that goes into it, with this approach, where I can't see anything at all, I think as informed consumers, we want to be able to see what goes into making these results. And indeed, it's our responsibility as lawyers, as legal professionals, when we're following the model rules. Rule 5.3 says we have responsibilities regarding non-lawyer assistance. I hate the phrase, by the way. I don't like the name non-lawyer, big controversy in law right now. But this is what the model rules say. And the model rules say that when you file a brief before a court, you are responsible for the work of everybody leading up to that, whether they're an associate at the firm, an allied professional, if they're a law librarian or a paralegal. You are responsible to supervise all of their work and responsible for the output. We don't have a case yet where a Stephen Schwartz of Rule 5.3, where we say that someone is responsible for the work of AI, but I guarantee you it's coming. And so we need to make sure that we are not the Stephen Schwartz of Rule 5.3. And then the third pillar, confidentiality. There's not much to say about this, except to say that we need to make sure that the trade secrets, the confidences of our clients are respected when we use these tools. And here, there's just a very important distinction between open models and closed models. The early versions of ChatGPT would actually use the prompts, use what you type in to train the model going forward. And this became an issue early on when Samsung engineers tried to improve their patents by typing trade secrets into ChatGPT and have it draft patents for them. ChatGPT then learned from the trade secrets of Samsung and started producing those trade secrets when other people would run searches. Not good. Separately, in the early version of Google and Bard, they said it was a closed model, that it wouldn't train based on people's prompts. But in fact, people started to see their prompts showing up in Google search results. And so Google had to retract that version of Bard, update it, and publish it again. And I'll just say that, you know, people who build these tools should guarantee that they're confidential, but they should, it's the incumbent on the lawyers who use them or the legal professionals who use them to make sure that they're using a closed model and not an open one. And I would just say, for very sensitive trade secrets, or things that you don't want exposed, you really shouldn't be uploading confidential documents into these tools. Okay, so it might sound from these warnings like I am skeptical about the tools, like I don't like them. I love them. I think they're great. I'm investing a lot of my professional career right now into building them. And one of the reasons this is true is that I think that generative AI and this class of tools has an unparalleled potential to close the access to justice gap. If you look at the American Bar Foundation's very important study now 10 years ago, the World Justice Project, anyone who has studied this will tell you that in about 80% of cases where someone has a legal problem, they're not addressing that problem with the help of a lawyer. They're going outside of the legal services market to address it. And simultaneously, people who address these problems without a lawyer lose something like 95% of the time. That doesn't mean that you win if you use a lawyer 95% of the time. It just means that if you're not getting legal assistance, you are most likely going to lose. Our judicial system is very hard to navigate. I think that obscurity is kind of built into court systems. There's probably some stuff we can do about that as well. But while we are talking about the model rules, I'll just say that the model rules prohibiting the unauthorized practice of law could have a real chilling effect on people who are trying to sell these solutions direct to consumers or make them available for free through nonprofits to these consumers. There is a company called Upsolve that helps people prepare bankruptcies, and a faith-based group in New York without a legal license was trying to help people to file their bankruptcies, to reorganize their debts and move forward with their lives using this software tool. And they were threatened with an unauthorized practice of law suit in New York. They've actually won that case. It's been established that Upsolve and the use of software does not constitute the practice of law. But it is not at all clear. This is the subject of the article that Jean was talking about at the top, where I'm basically saying that it's not true that software constitutes the unauthorized practice of law, but it shouldn't be either. We shouldn't be a close call. And by the way, if you're saying like, who cares? Like, it doesn't really matter if it's the unauthorized practice of law. UPL is a felony in like 5 states. You can do jail time for providing software that helps people with legal problems. So I want to clear this up while we're talking about the professional responsibility of publishers and of legal professionals. UPL rules 5.5 and 5.4 are definitely reading onto that as well. So I'm not skeptical about the tools. I think they're great. And I'll say that we have to use them ethically and responsibly. The tools themselves are the slowest, most expensive, and dumbest they'll ever be. They will only get smarter from here. We saw just 2 days ago the launch of OpenAI's GPT 4.0 for Omni model. It is 2 times faster and 5 times more throughput and 2 times cheaper than its most recent model, GPT-4 Turbo. Google is coming out with a version of Gemini called Ultra that is going to be better and faster. The tools are going to iterate and get better at solving these problems than ever. So I'm very enthusiastic about them. Also, recall the state of the art in 2022. I think that these tools have the promise of ending searches that look like this and resulting in long lists of documents that we read. And if we do it right, if we do it in a way that is accurate and transparent and protects the confidentiality of client information, then we can make sure that we don't end up getting rung up by the New York Times. Okay, I've got maybe like 10 minutes left. I thought I would take a second to maybe show what one of these tools looks like in practice, if that's okay, and then maybe take a few questions. Does that work?
That would be great. Thank you.
All right. So I worked a little bit for many years. People were talking about these tools in the abstract, like they were magic. I'd like to maybe just cover them in a very practical way. So I'll show you what retrieval augmented generation sort of looks like in practice. This is the Vincent tool from vLex. I'm going to run a search. It'll take about maybe 3 minutes. And I'll just narrate sort of what's going on here. So the first thing that we're doing, and I'm not trying to sell you the tool, I'm just trying to tell you how it works. We take the entire legal research database and index it using a new tool, not word by word like keyword searches. The technology is called vector, but effectively what it does is in each document, it finds the essential concepts and then indexes those concepts, creates a map. Concepts that are very close together are very similar, are close together on the map. Concepts that are very different are pretty far apart on the map. And then there's an entire map of the law of the US, 10 other countries now in vLex. And so what happens is when I run this search, the first thing that happens is we take the question and index that in vector. We find what the concept is being asked about, and then we place it on the map. And we find things that are related to it on the map. That's what's happening on the right side. And instead of 1,900 results, a bunch of documents that we read, in this case, we found 19 results, right? And these 19 results are all documents in the database. Each one of them has a summary. There's a confidence score at the end of how likely it is to address the question. And then here's an exact quote from that document that shows whether it's relevant or not. All right. And importantly, I can go through and I can say, I want to modify this list. I don't want to use this article from RAIL, the Journal of Robotics, Artificial Intelligence and Law. But I do want to use the cases and the statutes and the regs. In any event, I can see all of the documents that are being retrieved and used to answer the question. And then I get an answer on the right-hand side. So my question was, is a literary work created by artificial intelligence eligible for copyright protection? Okay, and the answer here is, under current US copyright law, a literary work created by artificial intelligence is not eligible for copyright protection. This is because the law requires that the work be an original work of authorship created by a human being. AI is a non-human entity, does not meet the criteria for authorship as defined by the Copyright Act and interpreted by the courts. And then it goes through and cites the foundational statutes for copyright, 17 USC 102 and 103, and then goes into case law, Thaler versus Perlmutter, the seminal case in this sort of spelled out here. And for all of these, they are hyperlinks. So I can click them and verify them. And then at the end, we have exceptions and limitations related to the question. Currently, there are no exceptions or limitations within US copyright law. However, if an AI-generated work involves significant creative input from a human, such as setting parameters or making creative choices, the human could potentially be considered the author. This does not extend copyright eligibility to the AI itself, but rather to the human involved in the creative process. So look, again, in the state of the art tools I've been building for 20 years, this legal research question would take, I don't know, 5-6 hours. I create this magical Boolean keyword search and I run it, and then I get 1,000 documents and I try to narrow that to something that I read, and I read them one at a time. And by the way, I probably end up with something like these 19 documents. If I do it really well, I get the key 6 cases and 2 statutes and regulations over many hours. And then I synthesize them and come up with the answer. We did that in about 2 minutes, 3 minutes here. This is using retrieval augmented generation. I'll point at one more. There's a skill in here called analyze documents. If I pull in, say, a complaint, I can analyze it right away and extract all the claims. I can make a list of the defenses to each one of the claims. This is a table of defenses for the complaint that I just uploaded. A timeline of events. These are the kinds of things that lawyers or associates would do when receiving a complaint. Over the next several days. We'll do it in about 5 minutes. So look, I guess in closing, what I would say more than anything is that these tools have amazing potential. I believe in them quite a bit. We can use them to assist clients better. We can use them to close the A to J gap. And we need to make sure that publishers and software developers who create them are doing so ethically and responsibly. And we need to make sure that we as users are using them ethically and responsibly. Do we need new rules? No, I think our existing model rules cover this pretty well. But I would just say that the onus is really on us. We are responsible for reading and verifying the cases, and we can do that with tools that provide the accuracy, transparency, and confidentiality that are the hallmarks of ethical use. All right, I'd be glad to take some questions if there's still time.
I'm going to ask a tough question right off the top, and I'm going to grab my privilege here and run with it. So this is great. I look at what vLex can do, and I think to myself, geez, I remember hours in a library trying to do all of this with paper. You remember that, guys, right? Paper? Yeah. And so what happens to the first year associate job with tools like vLex? And what does the future look like for the legal profession where tools like vLex exist? And basically that's the first 3 years after law school. So what now?
Well, I think I would say we should look to history, right? The best guide of what is likely to happen in the future is based in our past. And I think the closest analog here is probably electronic discovery. I mean, the truth is we've been using AI tools to remove some of the worst parts of the lawyer's job for many years. Before e-discovery, Many of you might be old enough to remember, we would do manual discovery, right? We would read through warehouses full of documents in manila folders. And that was how lawyers spent the first 1 to 3 years of their careers. They would learn by doing, but the things that they were doing were these very tedious, insane document review tasks. They were terrible. When I was a young lawyer, I worked at a big law firm in DC. My class was 52 associates in my year. And a year later, the firm won the ExxonMobil merger. We actually had to rent a building to hold all the documents that were reviewed. 0 of those associates ever made partner. They all quit. They got burned out by document review. So we introduced electronic discovery in about 2003. And electronic discovery allows us to review those documents by scanning them, by OCRing them, and by training AI to find the relevant ones and to mark the privileged ones. Now, we still review them, right? And we don't trust the AI completely, but the AI does the first step, the worst part of it. And the amount of time we spend is like 1% of what we used to spend. What happened? Did lawyers become less skilled because they didn't have to go through the hazing process of reviewing boxes of documents? No, they became more skilled. Are there fewer lawyers because AI took our job? Actually, no, there's more lawyers than there were in 2003, and they're happier. So at least the best history I can point to for whether AI kind of replaces those critical skills tells me that the lawyers will be better prepared, because instead of spending those years doing something that has nothing to do really with a lawyer's counseling task, they can spend more time learning how to help people, learning how to help clients, learning how to advocate in ways that have nothing to do with the most tedious kinds of work. And I'll just point out, we sort of take it as an article of faith that the mystery around what the law is, the epistemological dilemma, how do we know what the law is? Like, this is sort of considered a key part of lawyering. But why should it be a mystery? Like, what if we could figure out what the law is early on and spend that extra time like developing better arguments, finding the exceptions, working with clients to counsel them that the law is against them, and so maybe they should settle the case. Or the law is 100% on their side, so they should move for summary judgment right away. Anyway, my hope is that these skills will augment lawyers, not replace lawyers. And I think about representation of clients as a chain, not an event. And hopefully we can use these AI tools to replace the worst links in this chain, the parts that are most expensive for clients, the parts that burn out lawyers. But the key elements of that chain still remain very human.
Great. So just so you all know, those folks who are taking e-discovery, we didn't talk about this example beforehand, so thank you, Ed. And other questions for Ed? Yes.
With respects to one's effort using confidentiality and using these tools, do you believe there is a possible threat with cybersecurity when using them?
Did you hear
So
that?
I think I've got the question right. Is there a cybersecurity threat to using AI tools?
Yes.
Did I get that right? Tell me if I didn't though.
You got it. Yes.
Yeah. So I don't think there's a cybersecurity threat in using these tools any more than there is from using Fastcase or Westlaw or something, right? I mean, in all of these cases, you are kind of searching over a closed database, especially if you're using tools that protect the confidentiality of what you're putting into them, the kind of closed protective systems I was talking about in the talk. I don't think there's an independent cybersecurity risk. In my personal opinion, by the way, I think the greatest cybersecurity risks inside of law firms are laptops, thumb drives, and on-premises networks.